we shall be discussing the concept of levy of GST. Under the Constitution of India, Article 265 provides that no tax shall be levied or collected except by authority of law. So therefore, it is absolutely essential that in order to impose any tax, there has to be a charging provision. So now we shall discuss as to what are the relevant provisions of Constitution and of the GST law which pertains to providing for the levy or the charging mechanism. Under Article 246 of the Constitution, goods and services tax is imposed by the centre as also by the states. Centre imposes goods and services tax on every transaction throughout the territory of India, because after all, centre can make laws for whole of the India. On the contrary, every state is empowered to impose goods and service tax only in respect of that particular state. Therefore, Article 246 capital A clearly provides that the state shall make a goods and services tax law only in respect to its own state. Now, what is the meaning of in respect to its own state? That is a different concept altogether, which we shall be discussing separately. But at this moment, let us understand that the law, insofar as the state is concerned, would pertain to its own state, and insofar as the centre is concerned, would pertain to the whole of the country. Now, the tax which shall be imposed by the centre would be called the central GST, the CGST in short. And a tax which the state would impose would be state GST. So, for example, if UP would make its GST law, it would be UP GST Act. If Rajasthan makes its GST law, it would be Rajasthan GST Act. So, likewise, so as many number of states, as many number of state GST laws would be there. So, essentially, there would be two GST laws operating on every transaction. So, in order to illustrate how that would function, assume that a person goes to a restaurant. When the bill would come, let us say a 1000 rupees bill comes, then what GST would be charged on the bill? There would be two simultaneous GSTs which would be imposed. So on that 1000 rupees, assuming that the rate of CGST is 10%, there would be a tax of 100 rupees called the CGST. On the very same bill, assuming that the restaurant is situated in Rajasthan, there would be a Rajasthan GST at the rate of say 8%, so 80 rupees would be Rajasthan SGST. So essentially, in every transaction, there would be two simultaneous GSTs which would be imposed. So the imposition of GST would be in a dual manner. That is why it is called a dual GST. Now, on what transaction this GST would apply? The Constitution says that goods and services tax means a tax on supply of goods and services. So there are two very important things which needs to be understood. One, there is a concept of supply because tax is on supply. Second, that supply is of goods and services. Please note that the term supply is not defined in the Constitution. So it is left to the legislatures to find out its meaning. We shall shortly discuss how supply has been defined by the relevant law. But to reiterate, there is no constitutional definition of the term supply. On the contrary, the term goods and services are defined in the Constitution itself. Goods is defined in Article 366, Clause 12 of the Constitution as every commodity, materials or articles. And this expression has been understood to be of a very, very wide amplitude by our Supreme Court in several judgments. To name some, the judgment of Tata Consultancy Services, judgment of Associated Cement Companies, which have been followed in several other judgments, have laid down that the expression goods is a term of very, very wide nomenclature. and it refers to every kind of movable property, whether it be tangibles or even intangibles. So this is the definition of goods. Now, as I mentioned, GST is a tax on goods and services. Now, what remains to be discussed is services. So, while imposing GST on goods and services, 101st Constitutional Amendment introduced the definition of services in a very interesting way. In section 366(26)(a), services has been defined to mean everything other than goods. So therefore, now if you compare or if you put these two definitions in perspective, it can be seen that GST is on goods, meaning every commodity, article or thing, and it is also on services, meaning everything other than goods. So practically, essentially, a goods and services tax would be on every transaction, be it a transaction of goods or anything other than goods. And this would be the entire space, because if something is goods, it is covered as a tax on goods. If something is not goods, it is covered as a tax on services. So if we in that sense look at the imposition of GST, it is on every possible transaction, because it is on goods and everything other than goods. So this is the expanse of GST. Now the other concept, namely the supply of goods and services. So therefore what needs to be discussed is the expression supply. As I mentioned, supply is not a constitutional concept. Supply is a concept which has been defined under the Act. So before moving on to the expression supply, exact definition, let me first quote the charging provision of the GST Act. Under the model GST law, they have defined that GST would apply on every supply of goods and services. So again, as the Constitution mandates, tax is to be on supply of goods and services. Likewise, under the model GST law, they have defined that tax would be imposed on every supply of goods and every supply of services. That supply has been defined in section 3 of the model GST law as an inclusive definition. It's a very, very wide definition, and it says that supply includes all forms of supply. So therefore, first of all, as such, it does not define it. It only defines it to include something. And then it talks about all forms of supply. So it's like a circular definition. Supply includes all forms of supply. So the emphasis is on expanding the scope rather than defining it or rather than boundarying it. And then it gives certain illustrations to the definition of supply, like and includes sale, barter, exchange, lease. So supply would include all types of contours of any commercial transaction. The only thing it would say that it must be for a consideration, and the other thing that it must be in the course of business. So therefore, the expression supply has been defined that it may be any type of transaction, but that transaction must be supported by a consideration. Under the law of contract, consideration is considered to be a quid pro quo, which is an exchange. So for example, if A agrees to sell goods to B, and B in consideration of that agrees to pay rupees 100 to A, then A is supplying the goods as per the concept of this definition, and consideration for that is rupees 100. So there is a supply for a consideration, and then the definition of supply is complete. But this is not the only definition. Supply further includes deemed supplies. So it says that if any service is imported from outside India without consideration, that would also be a supply. Giving you an example, if a parent company outside India enters into an agreement with its subsidiary company in India that we shall be supplying you technology but without consideration, and that can happen because there is a parent company, there is a subsidiary company. In that case also, it would become a deemed supply, and there is no requirement under the definition of supply under section 3 that it must be supported by a consideration. So even if there is no consideration, it would be considered to be a supply. Likewise, there is another expansion in the definition. When it says, section 3 would say that any transaction which is referred to in schedule 1 of the GST Act would also be considered to be a supply, even though there is no consideration which is supporting this transaction. So if any transaction falls under the schedule 1 of the GST Act, then even though there is no consideration, it would be deemed to be a supply. So therefore, summarizing this position, there may be a supply under the first category, where a transaction is supported by consideration and it must be in the course of business. But then there are certain deemed supplies where even though there is no consideration, if there is an import of service from outside India, that still becomes a supply. Likewise, there are certain other transactions mentioned in schedule 1 where even if there is no consideration, it is deemed to be a supply. For example, to give you an example, a transaction whereby a business disposes its assets. So let's say there is an old computer which gets worn off, doesn't remain usable, and the business just gives it away to someone without charging anything. Even then it is considered to be a supply, because this transaction falls under schedule 1 of the model GST law. So this is the meaning of the expression supply, and on the definition of supply, whatever transactions are included within this definition, they would be charged to GST by virtue of section 7 of the model GST Act. Now this is the concept. Now let us go back and understand that assuming there is a transaction which is occurring, what taxes would be charged? As I pointed out slightly earlier, in a restaurant case, as soon as there is a transaction, there would be two taxes simultaneously applicable. One would be a CGST, one would be an SGST. That is the case where there is a transaction which is beginning in a state and ending in the same state. And so therefore there are no more than one state which is involved, and therefore there is no interstate dispute as such. However, take a situation where the seller is in state A, buyer is in state B, and goods are lying in state A and they have to be delivered to the buyer in state B. In that case, which state would charge the tax? And in that case, would the states themselves start fighting tomorrow as to who shall have the jurisdiction to charge tax? The Parliament was very well aware of this kind of an issue, and therefore at the time of introducing this constitutional amendment, the 101st constitutional amendment, they very categorically stated in Article 246 capital A itself that no state shall be competent to charge tax on interstate sale of goods. Likewise, when the sale is in course of import, in fact, the expression is not sale here, the expression is supply. So, likewise, as in the case of interstate supply, in the case of import of goods into India, so a supply which occasions import of goods into India, that is also a case where only the central government, that is the Union Parliament, can make a law. Now therefore, in cases where the transaction has the characteristic of interstate supply, or a transaction has the characteristic of import, then Article 269 capital A says that it shall be the state, it shall be the center alone which shall make a law in that regard, and that center shall charge tax on that interstate supply. Once that tax is charged, that tax would be apportioned on the basis of law made by Parliament to the center and the state. But the fact remains that no tax on that transaction would be charged from the assessee by the state. So let us take an example. Let us say, as I mentioned, state A seller sells goods to a buyer in state B. Goods move from state A to state B. There is a definition which defines what is an interstate supply. Section 3 capital A of the IGST law says that if the person who is supplying, namely the supplier, and the place of supply of the goods is in two different states, it is considered to be an interstate supply. And in such circumstances, it shall only be the central tax which shall be applicable. And this tax is called as the interstate GST, the IGST, integrated GST. So that IGST would be applicable in respect of an interstate transaction. So in this kind of a situation, it would be only one tax. Unlike that restaurant example, if a sale is of 1000 rupees, then the IGST would be charged at a consolidated rate of 18%. That rate is still not out. The IGST law says that once that the law shall be, tax shall be imposed on the interstate supply at the rate specified in the schedule. So today that schedule is yet to be decided, but assuming, because conceptually it is going to be a sum total of the central and the state GST, and recently the council has decided that there shall be 4 slabs of rates. Assuming our product is a product which falls under the highest or the general slab, namely the 18% slab, in that case IGST would be applicable, only one tax called IGST would be applicable on the sum total, on that whole transaction of 1000 rupees, and that tax would be charged by the center and the center alone. So therefore, summing this position, there are 3 different taxes which are levied under the GST regime. As I mentioned, one is the central tax called the CGST. So whenever there is an intrastate transaction which doesn't involve 2 states, their tax shall be charged on, called CGST, by the center. Second shall be the SGST. So wherever there is a transaction, again not involving 2 states, transaction completing in one state, and then it shall be called an SGST. However, if the transaction is of interstate character, namely where the supplier and the place of supply are in 2 different states, then it shall be considered to be a transaction chargeable only to IGST. So there are 3 different taxes on which levy shall be there. So these are the provisions relating to the levy of GST.